Thank you very much. Good morning, ladies and gentlemen. Delighted to have the opportunity to speak to you today. Topic, Brexit and the environment. And the way this is going to go, I'm going to start off by talking about some of the technical issues that arise in connection with a UK withdrawal from the EU in terms of the impact on domestic law. Then I'm going to talk about the international dimension and future relations with the EU and the different implications of different possibilities there. And then talk about environmental law and policy, what EU environmental law has done, what changes there would be in the event of withdrawal. And right at the beginning, I need to say where these ideas come from, in that the technical issues is mine, discussed with some colleagues and so on. The international dimension is very heavily borrowing on a paper given a couple of weeks ago by my colleague, Professor Robin Churchill. He knows about it. I've asked, I've got his permission, and so on, giving you his name. And that paper, along with something close to what I'm going to start with, were given at a conference held by the Society of Legal Scholars and the UK Environmental Law Association in Bristol a couple of weeks ago, where there were people from the Commission, people from the Environment Agency in England, people from various law firms, people from various industries, and so on. So some of what I'm saying is informed by, but in no way representing, the views of those people. So I'm trying to, in this, to capture a sort of wider feeling of what's going on. So start off with the technical issues in domestic law. Some people want us to get out of the EU. We want to get rid of EU law. It's easy. Where does how does EU law come to affect us? It's the European Communities Act, 1972. Repeal the 1972 Act and poof, EU law has disappeared. No more evil bureaucrats in Brussels, no more meddling judges in Luxembourg. Whole thing disappears. Nice and easy, nice and simple. Two-line Act of Parliament, all done. It's not quite like that. Real life is not quite like that, because EU law is embedded in our legal system in various ways. The whole nature, the whole point of EU law as a system, EU legal system, is that it's not something separate, isolated, out on its own. It is part and parcel of the everyday law, the everyday life of the member states. So when you look at this, you can see that EU law, provisions based on EU law, are embedded in our law in different ways. Yes, there are a few areas, a few examples, where all the relevant law is to be found in EU provisions. The treaty provisions, regulations, provide everything you need to know about the area. They provide a complete set of rules, but those are very rare examples. Usually there's some supporting measures needed at the UK level in terms of giving authorities powers to act, enforcement, implementation, and so on. But there are very few of those. Secondly, you have rules which are inspired by the EU, but are now to be found wholly in self-contained UK legislation. The whole content of the rule is embodied in UK legislation. For example, the various public registers there are in pollution licensing, permitting schemes, and so on, they were all put into the law in order to comply with EU provisions on access to environmental information, but the law is completely self-contained in the UK regulations. You don't need to look at the EU law at all for it to make sense. Thirdly, you've got rules which were inspired by the EU, again, and are largely self-contained in domestic legislation, although there are still some references, some things where you need to look for the EU measure. An example here is the Environmental Assessment Scotland Act 2005, driven partly by domestic reasons, but primarily by the need to comply with the Strategic Environmental Assessment Directive. But the key provisions, the key requirements are all in the Scottish Act. Yes, there is the occasional reference to EU material in setting the scope of particular provisions, but the Act could work on its own. It could survive. All the main operative provisions are there in the Scottish Act. It could carry on. If you got rid of the EU stuff, it could carry on all right, even if the EU law disappeared. But then you've got areas of law where incorporation of the EU law is absolutely essential for the EU law to make sense. Classic example here is waste law. What is the definition of waste in UK law? The definition of waste is anything that is waste within the meaning of Article 3.1 of the Waste Directive. So if we get rid of EU law has no power at all, that becomes absolutely meaningless. The whole UK framework falls apart unless the EU provisions are there some way or another. And finally, you've got legislation which has no role at all unless you've got the EU measures there. The control of trade in endangered species enforcement regulations. These provide for the rules on enforcing the import and export of endangered species. But all the substantive rules on what species are covered, what permits you need, when you need a permit, and so on, all those substantive rules are in EU regulations. So the UK regulations by themselves mean nothing. They'd be enforcing, if we got rid of the EU regulations, we'd have the UK law, but it would be meaningless. It wouldn't have anything to work with. So, EU law isn't something separate. It's not something we can cut off neatly. It's embedded. It's set in our law in all sorts of different ways. So, what happens on Brexit Day? I always think I call it Brexit Day. You could call it B-Day, and I'm sure there are jokes there and so on, but I've not quite been able to work out a respectable one I could use for these things. So, we could simply say on Brexit Day, have a big break, EU law no longer of any force, you can't refer to any EU law, we just forget about it. Cut those bits out. But if you do that, we're not getting rid of EU law and we have a mess. There's going to be a huge legacy of EU measures left because they're in form, they're actually in UK legislation now, even though they are inspired by the EU. There are going to be huge chunks of UK law with big holes in them, because it doesn't make sense without it. There'll be a legal vacuum on matters where the substantive rules are currently in EU regulations, in the EU treaty, and so on. So we've got huge problems in sorting it out. So, how do you avoid the mess? Well, two main options there seem to be. The first is between the decision to leave and Brexit Day, we review all the laws there are, every bit of legislation, every bit of case law. We identify which bits have an EU origin. We then think about them. Do we want to keep them? Do we want to amend them? Do we want to repeal them? If we want to keep them, we then reenact them in UK legislative form so that during the 2-year period between deciding to leave and the actual departure, we have completely reviewed, consolidated, dealt with all our statute book. Seems a bit unlikely. Bumper time, maybe, I don't know, maybe there's a job for all of us as lawyers to get on this, but time of austerity, is the government going to have the capacity, the time, the money to do it? It's not going to happen. But if you're going to say we just strike a line through everything EU, that's the sort of thing you need to achieve. So the alternative that seems to be almost inevitable alternative seems to be that you have to provide that all the law in force on Brexit Day continues to be enforced. Whether it's in form, it's in a UK legislation, or it's rules that are in form in EU regulations, the treaty directive and so on, I think you're going to have to say that all the law currently in force stays in force. Now, yes, during the run-up to Brexit Day, you can do some tidying up. You may want to cut out some of the most objectionable bits. But in order to avoid a legal vacuum, in order to avoid a mess, you're going to have some sort of continuity provision. You're going to have to say that we can't actually get rid of all EU law immediately, and so on. So, we've got to think, when you talk about pulling out of the EU, getting rid of EU law, we've got to think, what does that actually mean? It's very complicated. It's not straightforward. But EU law also affects our law in other ways. It has an impact on things. Where the law has EU origins, whether because we're interpreting EU law or domestic law based on it, the UK courts are currently bound to interpret it in the light of EU provisions and the case law of the European Court. And this has led to the courts producing interpretations which stretch the words of UK legislation in order to meet the EU purpose, stretching them in a way that wouldn't be acceptable in a purely domestic context. So, in the event of Brexit, clearly that obligation of the courts would disappear. There'd no longer be a justification for stretching the words. But a question arises, well, what is the court's approach to interpretation going to be? Unless the exit legislation expressly forbids looking at any EU materials, then the courts are still going to want to look at the EU materials to make sense of rules in our system which have an EU origin, because that's the only way you can make sense of it. So the EU context will continue to be one strand of interpretation, not the decisive strand anymore, but it would still be one strand of interpretation unless this is expressly barred in the interpretation provisions. Moreover, there's a question about what we do with existing interpretations. Do we reopen interpretations in recent years, where the courts have been led by EU materials, EU provision, EU case law and so on, down a particular line? Whereas if we looked at things on the narrow domestic basis, we might have taken another decision. For example, in relation to the definition of waste, hugely difficult, controversial issue at EU level, where the EU court has said a lot. Nobody understands what it said. One suspects even they don't understand what they've said. But that's led the interpretation down one way. Do we, after Brexit Day, do the British courts have the potential to say, right, we're going to forget all that, we're just going to look at the words of the definition and develop our own meaning of that? What's going to happen in relation to that? Hard to work out what's going to happen. There's then the issue of future changes in EU law. Well, obviously, after Exit Day, any future changes in the EU law directly aren't going to have any impact on us. But that might make it quite hard to work out exactly what was the state of EU law on the date of exit. If we've got this sort of continuity provision, how do you freeze it? Legal archaeology to try and find out exactly what the state, the understanding of EU law was on the particular day. And if we have any rules in our system, wherever they're found, that have an EU origin, would the courts be able to look at post-exit European case law in order to understand it? That would be still understanding, would be showing light on the context. Would the court be able to look at a post-exit case to help them understand a pre-exit rule that still survives in a court? What sort of arguments would you make about that constitutionally and practically and so on? So interpretation of measures which have survived in UK law is going to be a real challenge. Lots of scope for argument of what's going on. That's the courts, but we've then got to think about legislation and lawmaking power. European Communities Act 1972 confers on ministers very broad powers to make laws for the purpose of implementing any EU obligation or for the purpose of dealing with matters arising out of or related to any such obligation or right. So huge sweeping powers under the 1972 Act to make legislation. And this is a very heavily used power, probably far and away the most heavily used parent act there is, covering such major issues as the control of industrial major accident hazards regulations, the environmental information regulations, and coming to things that you'll all be more familiar with, the racing pigeons vaccination regulations Northern Ireland, and the sheep and goats identification and movement interim measures Wales Amendment Order. All dealt with, made under the 1972 Act. I do love the sheep and goats identification orders. They're just this lovely idea that somebody's going around saying, that's a sheep, that's a goat. So going to the zoo and getting puzzled when they get some of the more exotic species and so on. However, side issue, not central. In most cases, there will be overlapping powers in domestic law. There will be powers under domestic law to do with it, to achieve, to make law. But because there's had to be the 1972 Act's been there, we haven't had to worry too much about actually piecing things together, making sure there aren't any gaps, there aren't any lacunae. It'll be much more complicated to make sure that there is the power to do everything that you want to achieve. And the ability to rely on the 1972 Act has also avoided another big area of possible complexity and uncertainty. One of the features of the devolution settlements is that the Westminster Whitehall authorities have the power to legislate on any matter where you're implementing EU law. So where you've had an EU provision, you can use the 1972 Act without actually worrying too closely about exactly where the devolved, reserved boundary is. You can do it neatly without having to split things up and so on. If you don't have the 72 Act, you're going to have to pay much more attention to that. You're going to have to think much more carefully about, well, where exactly does this power lie between London, Edinburgh, Cardiff, Belfast, and so on. So we're going to end up with much more fragmented legislation. You're not going to be able to do it all in one. There's going to be an issue with that. And this raises another issue, which is a further indirect, but I think very important role of EU law at present, which is in dampening the consequences of devolution. Environmental law matters are largely devolved under the devolution settlements for Scotland, Wales and Northern Ireland. There were differences before devolution in the environmental law of each country. The whole point of devolution is there should be differences. But the fact that EU law accounts for so much of our environmental law means that all the jurisdictions are bound to operate within the same common framework. There are limits to how far they can go in developing their own law. There's no capacity for the countries to head off completely in their own directions, doing things completely differently. So that no country could decide to set its own water quality standards or impose much higher or lower standards on pesticides. You've got to meet the same framework. And in the event of Brexit, that constraint would be removed. You'd no longer have this common framework within which the devolved authorities have to work. And in some ways that's great. It allows greater diversity, greater divergence, greater capacity to reflect the local needs and interests and so on. But it also risks much greater fragmentation. It means that the law in the different countries can become much more different. Is that going to cause problems? Within the EU framework, the differences have been kept within workable limits. Without it, things can go off in completely different directions. And that might give rise to calls for some sort of coordinating body, at least to discuss these matters, as opposed to things being left. We know we've got to keep within the EU framework, and that provides limits. You may find arguments, well, hold on, maybe we should have a UK or a UK and Ireland or a UK and whatever body to discuss environmental standards to try to keep things still in line, even though technically authority is gone elsewhere. I mean, already we have the Joint Nature Conservation Committee trying to look on a UK level of certain issues which are devolved. Maybe we want to see that replicated in other areas as well. So there's been this impact on dampening devolution. So in terms of the purely domestic side of the consequences of Brexit, it's complicated. It's uncertain. We don't know what's going to happen. The exact terms of the Brexit legislation would be very important and would need to have tried to think through some of these consequences to work out what they're going to do. But the domestic angle is just one side of it. There are also major international dimensions. And as I said, I'm borrowing very heavily here from my colleague, Robin Churchill. And here we've got to think about three things, three key points to think about. First of all is that there are, in fact, provisions equivalent to the substance of much EU environmental law binding on the UK in a different way through international treaties. We tend to see them through the lens of the EU law because that's how they most directly come into our law. But there's an international obligation behind that's constraining what we're doing. Secondly, if we want to do business with the EU, there are environmental standards and requirements that can still be imposed even though you're not a member. And this is, of course, affected by the nature of our future relationship with the EU. So, looking at these, UK has treaty obligations, not just through the EU, but internationally, which actually cover a wide area of environmental law. Here, some examples Robin gives. The Long-Range Transboundary Air Pollution Convention and its protocols, SOx, NOx, VOx, and POPs. I think that's Santa's second team of reindeer, I think, sort of at this time of year. Your controls on those obligations that have to be met in relation to that. Marine pollution, the North Atlantic Convention. Nature conservation, the Berne Convention on Nature in Europe, the Convention on Migratory Species, CITES, International Trade, the Convention on Biological Diversity, again, OSPAR, the North Atlantic, and so on. All sorts of obligations, environmental obligations that we are bound by international law to meet. Chemicals, there are various conventions on prior informed consent and persistent organic pollutants. On EIA, there's the ESPO Convention imposing EIA requirements only in a transboundary context, but still important. And in relation to access to environmental information, access to justice and so on, the Aarhus Convention imposing obligations. So far from the UK being free to develop anything it wants to do in terms of its environmental law once it's out of the EU, we have all these constraints on us. Now, the impact of the international law obligations is rather different from the EU ones. Obviously, there are some gaps. There are some areas where there isn't the sort of provision, sort of measures that are under EU law. Detailed rules on waste within the country aren't covered, but anything to do with export of waste is covered. Some of the freshwater issues, carbon trading and so on, we're not as directly applied, but we're still going to have, hopefully after Paris, we're still going to have some obligations, and you may want to meet them in various ways. There won't be renewable energy targets and so on. And of course, if you're dealing with international law rather than EU law, the whole enforcement mechanisms are very different, a bit looser. Don't know how many international lawyers here there are, how rude you want to be about the effectiveness of international law and so on. There's a very different, much weaker, the treaties are much less detailed, the enforcement provisions are weaker. I think we can, probably everybody can agree with that. But there are still going to be constraints, still things that we have to comply with. And in terms of our relationship with the corpus of international treaties and so on, well, at present, as a member of the EU, where a matter is one of exclusive EU competence, it's only the EU that can deal with it. It's the EU that's a member of the treaty, that's party to the treaty and so on. So UK would no longer be, if it's no longer a member of the EU, would no longer have rights and obligations under these treaties. Big area here is fisheries, which is an exclusive EU competence. So if Britain left the EU, it would leave various treaty bodies as well, but would probably want to join them in any case, such as the fisheries commissions and so on, whereas an exclusive competence is the only thing that can work. I'm worried that Francisco's looking worried in case Robin got this wrong or something, but I'm going to explore that later. Equally, where the EU and the member states, where it's a shared competence, both the EU and the member states are parties to the treaty. In those areas at present, as a member of the EU, UK is bound by the common negotiating position that is adopted by the EU within its areas of competence. So if the UK left the EU, it would regain its independence, its ability to negotiate on its own and so on, rather than as part of the collective unit. So you gain greater freedom, but perhaps a less powerful voice in some circumstances. So international law is going to continue to impose constraints. Britain's not going to have a free hand. What about then trade? What about dealing with the EU and so on? Well, if the UK wishes to continue trading with the EU, which I suspect for many businesses is something they would want to do, we've got to think about how we get access to the market. And the EU has harmonised standards for trade within the EU, part of the free market, free movement of goods and so on all sorts of things, lots of environmental matters covered by the obligations. And the EU is able to apply these standards to goods coming into the EU from outside, from Britain after it's left. Can't apply higher standards because that gets into World Trade Organization issues, but it can apply the same standards. And in any event, the chances are that Britain's going to want to negotiate some sort of free trade agreement with the EU, some sort of agreement to make things easier. So what happens if you go about trying to negotiate a free trade agreement? Well, people talk about the European Economic Area, Norway, Iceland, Liechtenstein. Well, if you're a member of the EEA, you've got to apply all the EU internal market standards. All the market legislation you've got to apply, including the technical measures, sort of things that impose the standards on environmental standards and so on. And it's widely accepted that Norway, as a non-member of the EU, has a much better level of compliance with EU rules than some members of the EU itself. I'm told by Norwegian colleagues that it's just simply the trump card. When your legislation, when rules, regulations are being discussed, if it's an EU requirement, that's just it. Trump card settles the issue and it's dealt with. Switzerland has a slightly different relationship with the EU, but again, it's bound to apply all EU environmental legislation. The separate Swiss deal, which isn't quite as intense as the EEA, has as a downside very resource-intensive bilateral negotiations. And in recent years, there's more than a few signs that the EU is getting fed up of having to negotiate separately with Switzerland every time things go up, and the Swiss attitudes to various things. So whether the EU would be happy to go down that line with the UK may be open to debate. So if we think about the EEA and the Swiss agreements, close free trade agreements, well, still in effect you've got the same free movement provisions on goods and people to some extent, which seem to be the problem to some issues. Still possibilities of financial contributions being made. Big area of change, no longer bound by the common agricultural policy, the common fisheries policy. Haven't they been central to the debate? Have you heard those discussed in all the debate about exit? Here's the one big area where getting out of the EU would make huge differences. We'd actually have to think about agricultural policy. We haven't had to think about our own agricultural policy for 40 years because it's all done through the common agricultural policy. What are we going to do? How much are we going to subsidise farmers? Are they going to get any subsidy? How are we going to look after the countryside? Huge area opened up by coming out of the EU, even if we are in one of these agreements. But it's not exactly central to the debates and the arguments. Some bits of EU law don't apply to the EEA in Switzerland. The Habitats Directive is bathing water directive. Of course, the Habitats Directive is based on the Berne Convention, which we are a party to in any case, but never mind that. What's interesting about this arrangement is that the big thing that is always said is that you're bound by all the EU rules, but you don't have a seat at the table when they're negotiated and discussed. And at the Bristol conference, it was quite interesting with people there, slightly different perspectives on this. They said that you always saw Norwegian at these meetings, at the discussions. Occasionally somebody from Iceland. If anybody from Liechtenstein ever turned up, you wondered what on earth was happening and why they were there. When it came to a vote on anything, they always had to leave the room because it's only EU members that can apply, and that sometimes they then forgot to bring them back. You know, they'd go off for a coffee and you'd sort of be 2 or 3 items down the agenda before you realised that they'd been out for the next bit of the meeting. Sometimes they did that if there weren't enough translating headsets to go around. Of course, it was the non-EU members who were the ones who got left out, so they sort of were sitting at the back of the room without headsets and so on. Other people were saying, well, you know, their experience at other meetings was much more inclusive. And obviously, if the UK was in this position rather than just Norway, Iceland, and Liechtenstein, it would change the dynamics a bit. But the still fundamental point is that under this sort of free trade agreement, EEA, Swiss agreements, you're bound by a lot of the rules of EU law, but don't have a vote in the making of it. So what about other sorts of agreement? Well, you can look at the association agreements with, for example, countries further across in Eastern Europe. This example Robin took was from the Ukraine agreement, not the one that gave rise to the terrible problems over the last couple of years, but the earlier one that the EU had with the Ukraine. And if you look at that free trade agreement, again, you see huge constraints, huge obligations to comply with the environmental law coming from the EU. Ukraine had to incorporate the EU acquis on technical measures and standards, so it's still got to comply with the EU rules. Article 290 recognised the right of the parties to establish and regulate their own levels of environmental protection, but still an obligation to aim for high levels of protection, and continue to improve it, apply the precautionary principle, polluter pays, and so on. And crucially, a party must not weaken its environmental laws in order to encourage trade and investment. So you can't try to undercut the market by getting rid of the red tape on EU in relation to environmental standards. Now, obviously, it's an international agreement. It doesn't have the same direct enforcement mechanisms that EU law does, but it's still an obligation, a constraint, something that's going to limit what we can do. And looking further afield, the Canada Comprehensive Economic and Trade Agreement, it applies the World Trade Organization's Technical Barriers to Trade Agreement. Parties must cooperate to ensure that technical measures are compatible. And again, it's got the same sort of measures as the Ukraine provisions have on having high standards, on not cutting environmental standards to undercut trade and so on. And this one actually extends to include references to developing public access to justice, public access to environmental information and so on. So a free trade agreement will carry with it environmental obligations, burdens, constraints in a way that you don't escape by leaving the EU. If you don't have a free trade agreement at all, well, trade in goods will be governed by WTO law, in which case I'm sorry I'm not having the chance to meet Stephanie today. I know she couldn't be here, but quite glad on this slide because she'd probably put me right on it all. If we didn't have any sort of free trade agreement, well, there's clearly environmental law within the UK. We're totally free to do what we wanted. But UK exporters to the EU would still be significantly affected. The World Trade Agreement on barriers, WTO agreement on technical barriers to trade, would permit the EU to apply its technical standards, its environmental rules to any goods being imported, so long as they don't treat UK products differently from the products of other WTO members or the EU itself. They're not more trade restrictive than necessary to fulfil legitimate environmental objectives, and if they're EU measures, they should already be meeting that standard under EU law, and are based on relevant international standards unless inappropriate and so on. So, in order to do business with the EU, you're probably still going to have to meet EU standards, even if you don't have a free trade agreement, even if you're not in the EEA, even if you're not a member of the EU. So business isn't going to suddenly be able to do what it likes, be free. If it wants to do business with the EU, it's still going to have to meet EU standards. So in terms of the international agreements and so on, the consequence of them, it's an issue of swings and roundabouts. That there would be the scope for some relaxation of the environmental rules, but subject to our international obligations, subject to what's needed to secure access to the EU market. But there will also be major additional burdens, things that tend not to get talked about. That if we were out with the EU and not governed by, this wasn't governed by a free trade agreement, we'd have to comply, anybody trading with the EU would have to comply with the EU rules of origin. For goods imported to the EU, various standards, things on rules of origin, they require documentation, and the Trade Policy Research Centre in 2012 described that documentation, that procedure, as tedious, costly and disruptive to trade. So in order to get access to the market, simply to identify your goods, you're going to have a new set of burdens, which being a member of the EU or in a close trade agreement means we escape. And of course, there's the possibility of tariffs. If we don't have a free trade agreement, or if certain things are issued, are excluded, people trading with the EU would have the cost, the delay, the documentation of dealing with tariff issues or proving they don't have to deal with tariff issues. So a whole new set of red tape is created if you're dealing with the EU from the outside compared to dealing with it in the inside. So you've got to think you're just simply exchanging burdens rather than escaping from them all completely. Final thing to mention is just something about the withdrawal process at the EU level, added by the Treaty of Lisbon, Article 50 of the Treaty of EU Union, 2-year period for negotiation. Unclear whether that period can be extended, but it needs unanimity. All the member states have to agree, so if anybody's feeling a bit annoyed at Britain, they could say, no, we're going to stick to the 2-year period. It's apparently completely unclear whether once the process has started, it can be stopped. That once you've served your notice of withdrawal, is it simply a matter of negotiating the terms of the withdrawal, or if deals were done in the interim, you could say, oh, well, no, actually, we don't want to withdraw, or is it a one-way street? Apparently, that's completely unclear. The comments at the meeting in Bristol were that in the negotiations about exit, the other member states wouldn't be vindictive against the UK, but they wouldn't go out of their way to be accommodating either. So some of the things Britain wanted, if it was going to impose burdens, hassle, trouble on the other member states, why would they do it? I mean, they wouldn't make life as difficult as possible for Britain, but they've no reason to make it as easy as possible or to give in to Britain during the withdrawal process. So that's something about this, the EU aspect, thinking more widely about the international obligations. But what about environmental law itself? What about the impact on environmental law and policy? Well, an important thing to think about, as Maria Lee from London said at the conference in Bristol, is we've got to think about the context in which we're having this debate. We're talking about withdrawal and the impact on environmental law and policy against a background of deregulation and austerity. What we're looking at is a tide which would be towards less regulation, weakening environmental standards, rather than the other way round. Although in this context, it's interesting that this government, the one before, has had regular red tape challenges, trying to cut red tape for industry. It's had the competency review of the EU, what the EU should be doing and so on. And from industry, you don't get a huge clamour for change. There's not a sort of huge swell of things saying we should be cutting out vast chunks of bureaucracy, vast chunks of things. Industry likes, big industry at least, likes the EU standards. It gives certainty, it gives you a level playing field, it means you can deal with your neighbours and so on. You know what you're doing, you know where you're going. And the red tape challenges, so every government, just about every government I can remember, has had a promise to cut red tape. They never do. And actually sometimes what they've got, my best example I know is, it's many years ago now, one of the measures identified in Whitehall for getting rid of was the Weeds Act, which allows intervention if certain farm fields are infested with invasive weeds and so on. And somebody in Whitehall said, right, we can get rid of this. So it went out to consultation and they were overwhelmed with responses saying, thank goodness you're finally paying attention to this. When are you going to start enforcing it? When are you going to come round and do this? So on and so forth. So the Whitehall's perspective of red tape and that of some of the recipients can be rather different. So there's no deafening cry for fundamental change despite this deregulatory drive. What Maria said quite rightly is the debate would be completely different if we were talking about withdrawal from the EU for different reasons. If it was an anti-globalization, if we were trying to promote the environment, trying to get away from privatization, commodification, global economic, so and so on, the debate we'd be having on this from an environmental perspective would be completely different. But for the foreseeable future, I think next few years, we're still going to have deregulation and austerity as the vision for the future, rather than a more a greener, different view of the world. So that colours what we're thinking about here. So what has been the impact of EU environmental law? Well, a lot has changed since the 1970s. Few of us around here can remember the 1970s state of things were like, and EU law has been central to the big improvements we've seen. Bathing water, wastewater treatment, the Natura sites, hazardous substances and so on. EU law absolutely central to huge changes in all these areas. But there would have been changes in these areas in any case. We wouldn't be in the same place we were in the 1970s, but clearly without the EU measures, without the structure, the drive, the enforcement they gave, we'd have had different priorities, things would have moved at a different speed. So it's quite hard to work out exactly where we'd be today. When you think about the nature of EU law in the environmental area, crucial thing is it tends to take a long-term view. That the EU takes a long-term view and it imposes obligations on the member states. Member states' governments themselves are under obligations to fulfill environmental objectives, to meet environmental standards. So that what you have in EU law is that it can be very slow to emerge, but once it's there, it tends to take a long-term vision, looking 5, 10, 20 years into the future, and it's not subject to chopping and changing once it's there. It's not so vulnerable to change. It's based on long-term targets and roadmaps. And this is something the industry likes because they know where they're going, they know where they're planning, they know things aren't going to suddenly flip-flop around stuff. But it can be argued, if you know, this is a different issue, about is in some areas the nature of EU law now a weakness in an increasingly dynamic environment? Is actually the slowness to change, the fact that it's based on set standards, actually a problem, something that's arisen in relation to the current look at the Habitats and Species and Birds directives, because they're based on protecting particular areas of land. Well, if the climate's changing, that bit of land may no longer be useful. Are we stuck? Do we have a sort of very static model rather than a dynamic one? But long-term nature of EU law, very important, and the fact that it doesn't change so much. And when you look at the substantive obligations, EU law tends to specify standards, it specifies outcomes which must be met, it sets targets which must be achieved. We've got to do this. By a certain date, you will be doing this. Your products must meet this standard, and so on. Your water must be of this quality, and so on. And that's very different from the UK tradition. UK tradition was simply to state broad purposes, give authorities powers, and so on, and then the relevant bodies had wide discretion as to exactly what they were doing, wide discretion as to the outcome. They weren't bound to achieve particular targets, and so on. And that's a big difference in the way in which the law traditionally has worked. And if we were to leave the EU, we'd have to think about what would be the role of any targets and duties on ministers. Would there still be these targets, these obligations on ministers to secure the water quality, or quality of all our waters, to secure the quality of all our bathing waters, and so on? And how would they be enforced? At present, we tend to look to the EU mechanisms to enforce them. We look to the Commission, either acting directly or acting through complaints, to take infringement actions where it's felt the UK isn't living up to standard. If we got rid of that potential, what would happen? How would they be enforced? Well, Ian and I have talked a bit about, in the climate change legislation, what's the meaning of the legal obligation on ministers to meet the climate change targets. The Client Earth litigation on air quality in London, again raising these issues. The government's failing to meet its standards to to secure decent air quality in London and other places. And when you start thinking about enforcing that in a purely domestic context, you've got a whole host of practical legal issues to think about. Who is going to have standing to enforce these things? What remedy is appropriate when you're talking about long-term plans, long-term changes, when there are many different levers to be pulled, many different contributing factors to it? How does this impact upon government priorities? Do you actually say that the environmental targets are actually binding and tying the hands of future governments in terms of what they're doing? Does it mean that the court is actually changing spending priorities, forcing government to spend things and so on? How do you supervise the obligations going into the future? It's easy to say, today you're not meeting your standard. Well, what sort of court order do you give and how do you monitor what's happening into the future? So huge issues in terms of how within domestic law you might embody, you might enforce these sort of obligations, these sorts of duties on ministers. So, if the UK left, what would it mean for environmental policy? Well, I think you can be fairly clear, particularly at present, there'd be an aversion to anything that's seen as imposing high costs or being difficult to achieve. You know, without the EU law, I can't imagine we would have spent the millions we did on improving all our wastewater treatment plants around the coastline. So without the EU drive for bathing waters and water quality, it just wouldn't have happened. Yes, sites would have been improved slowly and gradually, but we'd still be doing that, I'm sure, rather than having it all, well, almost all done already. I think there'd be a reversion to a more discretionary approach, rather than having fixed targets which the European Court says have to be met. As far as the European Court's concerned, cost, political difficulties, the fact people don't like it, no excuse. The target, you've agreed the target, you meet it. Whereas UK courts would certainly take a slightly different view. Government would adjust things to allow more contrary factors to be taken into account. You'd have a weakening of accountability of government. The EU law requires government to achieve things. Without that external pressure, without external measure, how would you call the government to account in relation to its environmental policy? We'd have lower ambitions, air quality in particular, the example. That's so hard to deal with, and particularly the development around London, all the Heathrow arguments. I mean, that's going to be a big issue there. We'd have even more uncertainty on energy policy and where we're going. Hard to imagine we could have more uncertainty, but I'm sure UK governments would manage it. And above all, everything would be constantly vulnerable to change. Whereas the EU is providing standards, long-term measures, targets, roadmaps, and so on. Every change of government, every swing in the economy, and so on, you could have things being undone. So, that's perhaps the biggest lesson, is uncertainty. The whole thing about Brexit and so on is uncertainty. There's uncertainty about the process. Well, uncertainty about what the decision is going to be. Uncertainty about the process, even if we do decide to leave. Uncertainty about what departure would mean for law within the United Kingdom. There's uncertainty about the nature of our future relationship with the EU. How close or distant would it be, and what would the implications of that be? There's uncertainty about the future direction of policies. What would our environmental policy in 5 years' time be if we didn't have to work within the EU framework? Contrary to what the impression given by some advocates for departure, we'd still be subject to many constraints. Lots of things that happen in the UK would still be subject to constraints under our international obligations, or if we want to achieve access to the markets. And the big question really is how much of this is actually being planned for. How far have people got in actually thinking through these implications? How far are these considerations actually feeding into the debate, feeding into the arguments? Thank you.